quick look over at the motion to dismiss. Sorry, I pulled up Thugger Daily to pull up his thread. It's just Brian Steele's face. Um, let's get in over here. So the roundup, we've got civil case update. Brian Steele has filed a motion to dismiss, detailing his arguments for why the state has no claim on the item seized from Young Thug in the May 2022 raid of his home. So link to the Honorable Thugger Daily. Items Thug is defending is his ownership, and it includes $150K in cash. Remember, there was this whole statement from like the clerk from the county saying, like, hey, the civil forfeiture funds, there's no way we could have paid Nathan Wade $36,000 because we don't even have that amount of money. We can't have that amount of money in the civil forfeiture funds. And I heard that this was like over a year ago already. I was like, what? Excuse me. So I went and I looked at this civil forfeiture case because I remember seeing an article where they had seized over 100K in cash from Jeffrey Williams for civil forfeiture. That's before I really got into the YSL trial deeply. But I just hate civil forfeiture. Things like this happen. It's abused. Like, how did they just see this is Atlanta? And you have the civil forfeiture, their record keeping, they're telling us that they wouldn't have an amount seized of over $36,000 as an excuse to counter what Ashley Merchant had noticed, that some of the payments going to Special Prosecutor Nathan Wade were coming from the Civil Forfeiture Fund. That was a big record keeping oops for Fulton County, but ties in nicely here, that little throwback. Oh my goodness. So let's open this up. And let me link to AT. She does the AT Elian, but her name is Leanne. Maybe it's AT Leanne. I don't know exactly. I'm going to say AT Elian. We'll get over here. A new face maybe to pay attention to. She has some great commentary, and now she's part of Thug's team. Get this open. All right. So the captions in these civil forfeiture trials are crazy because it's the state. Really, the property is the party. So you get all of this. Lots of cars going on here, lots of stuff. Um, and then now we know the intro, right? We want to dismiss this complaint. There will be a deep dive over Unhappily Angry Lawyers channel. He's going to break down all the nitty-gritty on this today at 6. So linking to that in the chat. We're going to jump down to the summary. Skipping the case law. All right. So the complaint for forfeiture, this is key argument here. The complaint for forfeiture should be dismissed in part because OCGA 16-13-49B5 is unconstitutional. So there's a statute and it's unconstitutional. So we're arguing constitutionality of code. The 14th Amendment to the U.S. Constitution prohibits the state from depriving any person of life, liberty, or property without due process of law. The U.S. Supreme Court has held the right to enjoy property without unlawful deprivation, no less than the right to speak or the right to travel, is in truth a personal right, whether the property in question be a welfare check, a home, or a savings account. In fact, a fundamental interdependence exists between the personal right to liberty and the personal right to property. Neither could have meaning without the other. The rights in property are basic civil rights has been long recognized. The complaint from the state alleges that the defendant personal property is subject to forfeiture under 49B5, which allows for the forfeiture of any property found in close proximity to any controlled substance or other property subject to forfeiture under this code section. So, the Georgia Court of Appeals held in State v. West that the statute did not require a nexus between the item being forfeited and the controlled substances or other item in special proximity subject to forfeiture. Now, let's go up to this footnote that was up there. West involved a prior version, 16-13-49D, So prior version of a different subsection, which provided in relevant part that the following items were subject to forfeiture. Quote, all monies, negotiable instruments, securities, or other things of value which are found in close proximity to any controlled substance of marijuana or other property which is subject to forfeiture under this subsection. The constitutional concerns identified in West plainly still apply to the current version of the statute. So, we go back to the argument. However, as both the majority decision and the two dissents noted, there are significant constitutional concerns with this interpretation of the statute. But West did not raise the constitutional challenges to the statute, either in the trial court or on appeal, such that the issue was not properly before the court. Here, claimant is timely raising this issue. So, I think it's pretty interesting that, pretty much what this is saying is this is how the appeals courts would agree. But this individual didn't happen to raise this issue at the trial level. Here we are. You don't really have room to disagree with us here, unless you want to disagree with the appeals court. As Judge McFadden explained, the majority's holding regarding 49b-5 creates constitutional problems due to the absence of a nexus. Such a construction would authorize forfeiture of everything in a home where drugs are found. Every stick of furniture, every stitch of clothing. That's a quote. This cannot be what the General Assembly intended. Judge Boggs echoed that concern in his dissent. Taken to its most extreme point, this statutory language would permit the forfeiture of the big green egg on the deck, the coffee maker in the kitchen, and the light fixtures in the home, the bugles in the pantry, despite the lack of any nexus between those items and any crime. The bugles were added for emphasis. The statute is unconstitutional because it imposed... Oh, we can take a break? We've got some Doug. Heck yeah. Doug says the state's forfeiture case is crap. Usually it's a slam dunk for the state, not here. And what I think is so interesting is, we had at the trial, although unrelated to the property that's returnable, right? They're not going to return drugs, right? But we have Whitaker saying, look, we're not even going to send one of these charges for Diamante Kendrick back to the jury because you can't establish constructive possession. The stuff was up in the cabinet. So we actually see, this proximity issue coming into play with the way that the state tried to charge things in the indictment against Diamante Kendrick, and what the trial judge found was, nope. The constructive possession proximity doesn't make sense. We don't agree with that argument. Good to see you, Doug. Good to see you, Doug. All right. So he says focus on the forfeiture. The statute is unconstitutional because it imposes an excessive fine in violation of the Eighth Amendment. So first, 49b-5 violates the Eighth Amendment's prohibition on excessive fines, which applies to civil and rem forfeiture proceedings when they are at least partially punitive. The factors to determine if the forfeiture violates the Eighth Amendment's prohibition in excessive fines are, I thought this was cool to look at, right? This is new to me. Harshness or gross disproportionality of the forfeiture in comparison to the gravity of the offense, giving due regard to A, the offense committed and its relation to other criminal activity, B, whether the claimant falls within the class of persons for who the statute was designed, C, the punishments available, and D, the harm caused by the claimant's conduct. 2, the nexus between the property and the criminal offenses, including the deliberate nature of the use and the temporal and spatial extent of the use. And 3, the culpability of each claimant. So under the plain language of the statute and under the Court of Appeals decision in West, which is what we read above, does not require any sort of nexus between the item and illegal activity. As articulated in the West dissents, this would allow the state to seize literally anything found in close proximity to drugs, regardless of whether it was associated with the drug violation in any way. Given the Howell factors and the emphasis on the nexus between the item and the criminal activity, the lack of nexus required by the statute 49b-5 renders the statute unconstitutional. The statute violates the Eighth Amendment, and this court should dismiss any claim under 49b-5. So, really cool, and I suspect that Jim today is going to look at the way the state is arguing that, yes, we have a right to stake a claim in this. And they're probably going to rely on the language of the statute. It's allowed by the statute. Well, the state statute, if it violates somebody's constitutional rights, it's unconstitutional. So, very good. I think it'll be very interesting to see it play out, argued, an argument within an argument about state code versus your rights, your rights, your constitutional rights. So, another argument about the constitutionality of this statute is that it's unconstitutionally vague. To satisfy due process, a statute must both give a person of ordinary intelligence fair warning that specific conduct is forbidden or mandated, and provide sufficient specificity so as not to encourage arbitrary and discriminatory enforcement. Chat, what do you think about this phrase? Discriminatory, arbitrary, and discriminatory enforcement. Could it be? Do you think it's possible that we're more likely to try to apply this thing, even though it's not specific? We might try to go after somebody that has a really nice watch, really nice cars, lots of cash, more so because they have that stuff available rather than the criminal behavior we think that they're actually participating in. And we get a quote here that seems to be also from Metz v. State. Because vague laws without clear enforcement criteria can result in unfair discriminatory enforcement, a statute that fails to provide clear warning to the average citizen of what conduct is criminally forbidden or fails to provide explicit standards for its enforcement to law enforcement officers will be invalidated as unconstitutionally vague. Yeah, and there's no statute letting me know that if I post something on Instagram, you're going to tell me that everything in my home is the proceeds of a crime. So the prohibition of vagueness in criminal statutes is a well-recognized requirement, consonant alike with ordinary notions of fair play and the settled rules of law. And a statute that flouts it violates the first essential of due process. This doctrine applies not just to statutes that define the elements of crime, but also to statutes fixing sentences. We get here from United States v. Batchelder. That's kind of a cool name. So, too, vague sentencing provisions may pose constitutional questions if they do not state with sufficient clarity the consequences of violating a given criminal statute. And hopping over quick to the chat, Aaron says, I wish the hearing would be streamed. I want to hear Brian and Ashley make their argument so bad. It's not going to be streamed? Or you're saying you wish, like you still hope, but don't know? I think we might end up getting a stream. And what's even better is I think the hearing is scheduled for August 18th, which would have been Patel's trial start date. Like jury selection, maybe going right into opening statements, was scheduled for the same day. And now that's off the calendar. So we'll see. I think, yeah, Roblox, I think I heard mention of someone streaming it, maybe Miss Sylvia. And I think Kathy Roussan said as the time approached, got closer, Law and Crime might consider. So let's see. Although would they make the arguments on separate days, perhaps? Maybe? I don't know. I'd want to be there if all together. But I think it has been scheduled for the 18th for some time, and the Patel trial was set for the 18th for some time as well. So here, 49B5 does not give a person of ordinarily intelligence, fair warning as to what activity will allow their property to be forfeited, and does not provide explicit standards to law enforcement. And another main issue, right? The lack of clarity on what law enforcement is supposed to do. Like, law enforcement often doesn't really have a full understanding of the law the way judges and attorneys would, and legislators. Neither a person of ordinary intelligence nor a law enforcement officer. That's a funny, I know it's just to establish the two different roles and issues, but it's funny to make the distinction here between neither a person of ordinary intelligence nor a law enforcement officer to suggest that they are separate categories that don't overlap, has sufficient guidance to interpret the statute. Instead, the statute suggests that literally any piece of property in close proximity to any controlled substance or any other item subject to forfeiture could be seized and subject to forfeiture. For example, if a car is subject to forfeiture under 49B2 because it was used to drive to a drug transaction, and the car is later parked in a garage, any item in the garage or the garage itself could potentially be seized. Even if there are no controlled substances present, there is no guidance for law enforcement as to what should rightfully be seized and subsequently forfeited. Given the lack of explicit standards for its enforcement, the statute allows for unfair discriminatory enforcement, as evidenced by the state's use of the statute in this case. Accordingly, it is unconstitutionally vague. The statute is unconstitutionally overbroad. So, a statute is unconstitutionally overbroad if it reaches a substantial amount of constitutionally protected conduct. First, the court should consider whether the statute's overbroad by determining if it reaches a substantial amount of constitutionally protected conduct, and if so, it should then determine whether it's subject to a narrowing construction. In State v. Fielden, the Supreme Court struck down a statute that was so overbroad in its scope that it leads to an absurdity, manifestly not guided in by the legislature. So there's a quote that was declining to narrow the statute to avoid the constitutionality concerns because doing so would be less a matter of reasonable judicial construction than a matter of substantial legislative revision. So you got to change the wording. We can't even fix it by interpreting it differently. There's no way that we can narrow through our interpretation. It's just, you got to change the statute. Here, 49B5 is unconstitutionally overbroad. The statute plainly infringes on the individual right to enjoy property without unlawful deprivation. Given the breadth of the statute, it clearly, quote, reaches a substantial amount of constitutionally protected conduct, like owning property. The statute subjects innocent property to forfeiture, even when completely unconnected to controlled substances, as described above. As the dissents expressed in West, there is virtually no limit on the items that could be seized. So it's unconstitutionally overbroad, and the complaint should be dismissed to the extent that it relies on that statute subsection. Now, we're going to get into more specifics on why it's an issue in the way that it's applied here. So now we're going to argue that it's facially unconstitutional as applied to the facts of this case. So, because it allows any forfeiture of any item that's in close proximity to a controlled substance or to any other item subject to forfeiture, this manifestly infringes upon the constitutional right to property described above and violates the rights of the people. It too lacks a plainly legitimate sweep, and 3, unconstitutionally impacts a fundamental right of people in a large fraction of the cases to which it applies. So as explained in West, the plain language of the statute places essentially no limitations. And don't you think they love this? They're like, no, don't take this away from us. Essentially no limitations on the state's ability to seize and forfeit property, as it requires no nexus between the seized property and a violation of the Georgia, I forget what this stands for exactly, but it's their code. But I think there's like statutory authority or something like that. And it's unconstitutional on its face. But it is also unconstitutional as applied here, where the state seeks to forfeit extensive property that has no connection to a violation of GCSA simply because it was at a claimant's house. And it's a big house too, right? It's not like, all right, I'm in my one studio apartment, and so obviously everything's really crammed together. We're dealing with someone that had a huge property. So, and I'm not saying that the constraint should make a difference just because someone has a bigger square footage home than not. I'm just saying it's especially absurd. Let's see. All right. So complaint should be dismissed. 49B4, going to a different subsection, is unconstitutional. So, and this isn't a subsection. This is a subsection here. So, any interest, security, claim, or property or contractual right of any kind affording a source of influence over any enterprise that a person has established, operated, controlled, conducted, or participated in the conduct of, in violation of this article or the laws of the U.S. relating to controlled substances, that is punishable by imprisonment for more than 1 year and any proceeds. So, the state's like, oh my God, they said enterprise, call them an enterprise. So this is from subsection 49B4. Georgia's appellate courts do not appear to have determined what, quote, affording a source of influence means. The source of influence language is apparently taken from the federal RICO statute, permitting forfeiture of any property or contractual right of any kind, affording a source of influence over any enterprise which the person has established, operated, controlled, conducted, or participated in the conduct of, in violation of section 1962. Do you have a footnote? Okay, so they're saying that the term was also in a prior version of 21 USC section 848, but no longer appears in that statute. But there are limited cases on what this term even means in federal court. So if we go over to US v. Vagueness, noting the dearth of case law, I almost said coleslaw, on what a source of influence means. By way of example, the 11th Circuit has upheld a forfeiture order under this provision when the defendant bought homes when he had little reported income and used them almost exclusively as stash or money counting houses. So we're using the thing that we're putting money into that holds value, right? A home can hold value in equity. We're using it to carry out things related to our enterprise and our source of influence. As with subsection, so 49B5, this court should find that 49B4 is unconstitutional, such that the complaint should be dismissed in part. First, the extremely limited nexus required between the item and any illegal activity demonstrates that the statute allows for forfeiture that violates the Eighth Amendment's prohibition on excessive fines. Second, 49B4 is unconstitutionally vague because there's no guidance to property owners or law enforcement about this affording a source of influence. 49B5, as with 49B5, the statute leads to arbitrary enforcement, given that law enforcement officers have no meaningful guidance as to what's actually subject to forfeiture under the statute. Third, and finally, the statute is overbroad because it permits for the forfeiture of innocent property, infringing on the owner's right to the enjoyment of his property. This court should dismiss the complaint to the extent that it raises a claim under 16-13-49B4. So there's two subsections that make it vague. The interpretation of what's close enough, what's the spatial range of property that's considered to be, in proximity to the other thing that we want to seize. How big is the bubble? And then conceptually tying something to a source of influence for an enterprise is also extremely vague. Let's see. This is pretty repetitious. The source of language, the source of influence language, it's unconstitutional. It lacks a plainly legitimate sweep, and it impacts the fundamental rights. And then here, the statute is unconstitutional as applied here because it is being used to deprive claimant of his property without showing any connection between the property and any violation of the GSCSA. The seizure of jewelry and cars in this case demonstrates that law enforcement officers lack sufficient guidance on what is subject to forfeiture under these provisions. Where is the watch? Furthermore, the complaint fails to allege any facts demonstrating that the seized property affords a source of influence over a criminal enterprise in violation of the GCSA. So, accordingly, 49B4 is unconstitutional on its face and applied here. So I thought this was really interesting to see spelled out. I think a lot of this, thanks for Thugger Daily queuing us in, but Leanne Webster, welcome to the team. Shout out to Leanne Webster, obviously Keith Adams and Brian Steele as well. I'm going to be over checking out a deep dive When Happily Angry Lawyer covers this later. That's in the description if you want to pop in. It's scheduled for 6 p.m. Eastern. I think right after that, around 6:30, Tay-Biz is doing discussions on the Mickey Steins case. And again, Tay-Biz is also going to be doing an interview with Taya Adams in relation to the Mickey Steins case tomorrow, Friday. So come have some Friday fun with that. Both of those are linked in the description. Wait, I'm just popping over here and seeing a Pokemon joke.